So next up, we have a very interesting panel discussion called From Algorithms to Genes, Ensuring Patentability in Disruptive Technologies. So in this panel, we shall discuss three key criteria for patenting these innovations, including novelty, non-obviousness, while also addressing ethical concerns and the role of artificial intelligence in shaping patent law. It's my honor to introduce our moderator for this panel, Dr. S.K. Murthy, co-founder of IHIPP and founder of Satatam Kritam Legal Solutions LLP, who is a seasoned, Dr. Murthy is a seasoned patent attorney specializing in US and Indian patent laws, patent preparation and prosecution. He also trains professionals and improves IP culture within organizations. Welcome, Mr. Murthy. So joining Dr. Murthy would be Dr. Madhuri Mani Roy from Cooley LLP. She is a partner specializing in patent portfolio strategies for biotechnology, pharmaceutical and chemical companies. With a PhD in neurobiology from Stanford, she excels in patent preparation, prosecution and due diligence. Welcome, ma'am. Next, we welcome Dr. Neeti Diwan from RK Diwan and Company. With 15 plus years of experience, she specializes in patent drafting, IP strategy, trademark registration. Dr. Diwan is also an active member of global IP forums and prestigious communities like INTA. We welcome you, ma'am. Next, we have Mr. Karthikeyan Srinivasan from Sun Mobility. With 25 plus years experience in automotive innovation, he leads EV battery swapping solutions and IP management driving key industry standards. Welcome, sir. Our fourth speaker is Ms. Manika Arora, Associate Partner at Lal and Sethi, who is an experienced IPR attorney and registered patent agent. With a background in biotechnology and IPR from IIT Kharagpur, she specializes in securing patents for multidisciplinary innovations. Welcome, ma'am. Finally, we welcome S. Senthil Kumar from Hitachi Energy. With an expertise in R&D, innovation and IP management, he specializes in digital platforms, automation, power apparatus diagnostics and high voltage systems. Welcome, sir. Now I'd like to hand over the proceedings to Dr. S.K. Murthy for this panel. Thank you.
Thank you, Pradeep. Greetings all. We have a fantastic panel. I don't have to underline or emphasize it, as you can see from their profiles. We will have a fantastic discussion today, and the title of this panel is Algorithms to Genes, Ensuring Patentability in Disruptive Technologies. So let us start with the title and see what it means, right? And demystify it a bit and then see how we can proceed. Algorithms to genes is not just two words. It is a continuum starting from algorithms to genes, encompassing everything in between, right? So that is what this title is meant to be. And when we are talking about this continuum, we have several disruptive technologies. And of course, disruptive technologies are not new to the world. The world has always been disruptive. But at this point in time, disruptive technologies has acquired a meaning which is huge. Why I am saying that is, we have so many things coming together at the same time, right? Earlier, disruptive technologies was kind of serial. Now it is, all of them are occurring at the same point in time parallelly. Just to give you a few examples, we'll start with what's happening in the communication domain, right? If we look at 3GPP, right? Cellular standards. And if we look at IEEE standards, Wi-Fi standards, there have been several advancements happening in the communication technologies. Similarly, there have been several advancements happening in the computing industry, right? It could be parallel processing, it could be several technologies wherein we have technologies like SIMD, SIMT, several things happening at the same time. And at the same time, we have explosion of data and how do we process this data. And of course, AI is all encompassing. We are not specifically talking about AI today, but that is one small part of the discussion that we are having. And on the application side, especially if you look at the use cases, self-driven cars would become a reality very soon, right? And there is so much of technology that is going into these automobiles. This will be the new smartphone in the coming times, right? So, given all these things happening together almost parallelly, it is important to see what disruptive means in this present context. Right? So we will start with what disruption means in the present context. I would turn to you, Karthik, and please tell us what disruption means to you, and if you can give an example from your own industry, it will be fantastic.
Check. Thank you, Murthy. I think thanks to GIPC first of all for hosting this session. Very nice, well planned, and continuing on disruption. So first point is, what do we call as a disruption? When there is a confluence of technologies and that affects the customer, the end customer, that are us in various forms. So be it automobile industry or medicine industry or any industry that you take, the customer convenience comes first and customer comfort, and there is a big impact on his productivity, cost, and the outcome of the product. So whatever we create as products for the customer to use, when there is mass adoption of that particular product because of its convenience, cost reduction, or high productivity for the customer, that's what we call as a disruption. So the first disruption would be people were traveling in horse carts or whatever. So 150 years ago, someone thought of an engine, and that's where disruption happened in terms of mass adoption globally of in the automobile industry itself. And we see several examples in the past. The IC engine has remained kind of constant over the several years, but we are also seeing continuous innovations happening in the industry with respect to varied fuels. At the same time, increasing the efficiency of the vehicle, customer gets more and more mileage. All of us must be remembering, I'm not particularly branding any company, but all of us must be remembering the favorite ad that finally someone explains about a rocket and then someone says, "Kitna deti hai?" So finally the customer says, how much does it give for him? That's what he's looking at. So if we have a disruption in terms of if we have a confluence of disruption, meaning be it cost, quality and productivity, and now the recent thing is user experience. As we crave for more and better lifestyles, right? That's the user experience we are all thinking about. So it's all, the roti kapda makan becomes very basic, and after that what? That's what the question we are all solving for. And once we hit that, customer sees a major benefit in his lifestyle or in his way of living, or in his, even for the bottom of pyramid, if there is significant cost advantage, that's what is disruption is all about. And for that, whatever technology that we are working on, that solves that particular problem of customer for mass global adoption, that's where disruptive technology plays a huge role. And IP lies a common thread, because in this current world, no industry is separate by itself. Even in automotive industry, we start with IC engine, and then there is nanotechnology, nanomaterials, and alloying materials which come into auto industry. And there is, like Murthy said, about communication, right? So we have cars with internet inside right now. A lot of communication happens within the car as well and outside the car as well. So connected cars became a reality already. And 5G, AI/ML is entering cars as we speak. So there is no particular industry which is now standalone. There is actually all the industries are tied in together for solving the need of the customer, and that's what disruption is all about. We need IP lies a common thread. The role IP plays is very crucial, that it has to tie this, and when we see technologies transcending different industries, that's where IP can play a major role and then get the benefit to the inventors of the technology. Thank you.
From your experience, what does disruption mean to you in your industry? And if you can give an example of how your industry is getting disrupted, it will be fantastic.
Right. First, for the understanding of the word disruption, I'd like to use what SK you had mentioned, where you said disruption now could mean so many things coming together and rapidly changing things. that's what I would see in the energy industry, particularly how fast we are and we need to be transitioning from the fossil-based energy sources to renewable-based energy sources. And in this whole journey, the game is about accelerating this transition. So how fast can we accelerate? The technologies that support that, that is what is causing disruption. Going further into it, what we would see is that a classical energy system, or particularly getting more specific to power industry, a power system used to be that at a centralized location, we used to have the source, a power plant, and then the power, high power is transmitted to these high voltage lines into wherever the cities or the distribution would happen more locally. But what nowadays we would find is more and more distributed energy sources, distributed consumption. The whole grid, the concept of grid where you had a centralized energy generation and then transmission and then distribution, that is changing to maybe a mix, or who knows, maybe a more distributed system than the centralized system as we go on. So that's also a big change or disruption that we would see as how the grid is. The other aspect is the grid today is not just about the electricity, like how the electricity transmits. The grid can be seen equally as where there is communication, where there is digitalization. So it's a grid of communication and digitalization as well. And why is this required? Because more and more we integrate, say, renewables, we integrate various loads. What we see is from the way the sources behave or way the loads behave, example like renewable, it's not that all the time the power is available, maybe it changes with time. Generally, I mean, say last 10 years or 15 years, this problem was well known, but nowadays there's other type of problems are also coming, or challenges are coming, which is, if we talk of a data center, say AI is also an example. When you are doing a query, the Google query, the power that is needed, or the computation power that is needed is, when you want to compare that with the new generation computational requirements, say Gen AI, you want to compute, or it is making this model, at that time the power requirement is so huge that you may see from the load side also, your consumption is changing very fast. So at 1 minute it may be 10 times more consumption, at the other minute the consumption is much lower. You need a grid which is that flexible to take care of the change in the source, to take care of the change in the load. And here is where, like I said, the technologies related to communications, about all the computations that would happen, becomes very important. And therefore, the new grid is not just electricity grid, it is also a grid which is having all this data connected and the computing and how fast you enable it. So it's equally a digital grid. These are the disruptions.
Thank you so much, Sanjay. Madhuri, from your perspective, what is disruption according to you in biotech industry? And if you can back it up with an example.
Absolutely. So I would say in the biotech industry over the last 2 decades, there's literally been an explosion of rapidly advancing technologies, which are all in and themselves disruptive. So I can give examples, but then I want to move away from that and sort of give an overlaying example. So for those of you in the bio and biopharma field, things like next generation sequencing, CRISPR-Cas-based gene editing, stem cell therapies, adoptive cell therapies, predictive diagnostics have literally upended what can be done in a short period of time and what is being delivered to as therapeutics and as advanced medical technologies. But having been doing this now for nearly 2 decades, these have been technologically disruptive. But I think traditional patent law principles continue to apply to these technologies. Novelty, obviousness, enablement, written description, and the like. And we continue to look to those to guide the patenting and protection and exclusivity strategies for these technologies. But I feel like in the last 5 years or so, with the advent of big data, in silico screening, machine learning, algorithm development, all of these to enable discovery and research is really rapidly pushing against first principles in patent law. Probably as it applies to your industries as well, but definitely in the biotech industry. So for example, it's well accepted in the life science, in the biological and chemical arts, that these are unpredictable arts. So that means 2 things. One is the amount of data you need to show that you have enabled your invention is pretty high in these arts. And this is in light of the broader the claim, the more you need to show for enablement. Conversely, on the inventive step side, obviousness side, it's pretty well accepted that even small changes in a structure, in a compound, in a molecule, in a large molecule, small molecule, can give rise to unexpected changes in efficacy, manufacturability, usability, and so the patentability of even small changes, as long as you can show the data, are well accepted. Where I think this is getting turned on its head, and we're rapidly trying to keep up when we advise our clients as to what a specification, a complete specification needs to have, and dealing with the patent office is with the inclusion of all of these in silico screening, big data into the application as data actually arguably shows enablement. You actually have enablement in certain patent offices that accept such data, modeling data, predictive data, in silico-based data, that maybe we can get broader claims and you meet your test of enablement. Put that aside for a minute. On the other hand, with inventive step, the narrative for all of us in the life sciences space is this small change I made to my structure led to this unexpected change, unexpected result, and therefore my invention is inventive. Now with the advent of predictive analytics, again, I'm bundling all of this, I'm not a computer scientist, but sort of that kind of approach, what was previously unpredictable might actually arguably be predictable now. And so can we go to a patent office and say, actually, that one small change, look at this data, or can the patent office come back to us and say, well, that one small change, it was predictable using this tool, or that AI tool, or this machine learning tool. And I think we, at least in the life sciences space, in the small and large molecule space, I think in the next decade, we're going to come to this new equilibrium vis-a-vis broad claims with a new interplay between enablement and inventive step. And it's just something we have to be on top of with our specifications, with our clients, and maybe I'm getting to the takeaway, but that's what I'm seeing in when I think about disruption.
Thank you, Madhuri. So we'll move to Murthy. Are there issues in patenting these disruptive technologies? What are they? What issues or challenges do you see in India more particularly?
So what I see is that for these new technologies, I wouldn't call them disruptive technologies because per se I feel that we have been exposed to disruption from ages together. There has been a lot of development which has changed the way we communicate, we live, we we work in the industry. And as IP stakeholders, whether it is the patent office or it is the attorneys or it is the inventors or applicants, they have been able to handle that and find way to patenting and enforcing such rights. And then there is also what we see is not just disruption, but if you apply the psychological concept of positive integration, positive disintegration. So what happens? There is a disruption, but you also see that these technologies, since there is so much of information available, and people are using development happening in one industry into another industry, bringing everything into a very cohesive and wonderfully coordinated effort to, for example, intersection of genetic engineering with computer science, electronics with computer science. We talked about automobile with AI. So this is bringing also a very positive integration. The patentability issues, the challenge, again, the criteria will remain the same, like novelty, inventive step, and industrial applicability. What I see is the main challenge is not in the novelty, but in the inventive step, because even in the present age and even in the past, we always had problem with proving inventive steps. And if we see that mostly in most jurisdictions across the globe, there has not really been a clear-cut definition of person's skill in the art, and that's the person's skill in the art always remains is an elusive figure. So we don't know whether it's a master's degree or a bachelor's degree, or it is a practical experience in the field, or it's like how do you define that? So that has, yeah, the person. Exactly. So, and now with these AI tools and the kind of information on internet and accessibility to so much of information, and again the ability to analyze and cohesively retrieve a lot of information with one prompt and one query that you fire in a search engine. The expectation of inventive step and the or determination of inventive step is going to become more and more complicated, and that's where I feel that the challenge is. And also there are some jurisdictions like India where we don't have tools like, let's say, utility model. If we, this has been proposed from time to time in, earlier from 2017, and then when the policy came up. These are, and we don't have things like second medical use, or we don't have utility model. If these kind of alternative methods of protecting are brought in, especially when this is, there is so much development happening very quickly. It is not so, as somebody else also mentioned in the previous panel, that by the time you really the technology gets patented, it's gone obsolete. So if we have utility model come up, or we are allowed second medical use, then I'm just giving these as two examples from two different industries. This will also be helpful in the patentability of these inventions.
Same question. You have any other perspective or you want to add?
Okay. So I will speak about biotechnology and life science domain with regards to issues in patentability. I'll just step back a little and I'll start with the disruptive technology in this field. So once the disruptive technology arises in this field, businesses, they really have to push forward and either adapt these technologies, acquire these technologies, or incubate businesses to have competitive edge. At the same time, the problems that are being faced by the businesses are proactively, even if they go to filing of these technologies, there is very limited resources, limited knowledge. There is a lot of ambiguity of what to be filed, if it will be accepted or not. So with regards to that, see, we have to understand that traditional strategies may not work now, and we really need to have a very dynamic patent IP portfolio, not just patent. It has to be a combination of trade secrets, copyright, so forth and so on. With regards to patenting, we need to have multiple patents with regards to different aspect of the same technology, multidisciplinary patents. So these are some key takeaways. Also, we have to understand that unlike in the ICT domain, in biotechnology or life science domain, even with respect to the disruptive technologies, they are not as fast moving. So you really need to give time. You really need to give time with regards to research, testing, and then regulatory approval. So patience and agility have to be balanced with respect to the business side. With respect to patenting of these inventions, what I see the main problem, not the main, one of the problem comes is with regards to the morality or ethical issues in terms of biotechnology inventions. There is issues with regards to finances when you have to file multiple patents and you still don't have clarity. There is a lot of ambiguity of to what will be enforced. Even though you end up filing it, what's the protection you will get there? Issues with regards to integration of AI in biotechnology, of inventorship, of ownership. Issues with regards to, like ma'am said, with regards to inventive step determination. We need to have more clarity on these aspects. These are some of the issues that I would like to highlight. We really need to look into this and find solutions.
We got a glimpse of the challenges that Indian IP system would be facing. Similarly, what would be the top 3 things or top 3 challenges that the US system is facing, especially from a perspective of disruptive technologies? Murthy.
So I think one of them is global. It's sort of AI-assisted inventions, use of AI tools, and AI-based subject matter eligibility. In the last year, since 2024, in February, then April, then July, 3 times the USPTO has put forth guidance for each of these 3 subjects, adding to a growing body of continued growing body of gray area. They give examples, and it's based on case law. Not a lot of it has been litigated yet, but so that's, I think, one area where there continues to be an evolving conversation. The other one, closer to my practice on a day-to-day basis in biotechnology in particular, is the use of artificial intelligence, machine learning, other kinds of tools for such assisted predictions for diagnostics, especially in, for example, early cancer detection and subtyping of particular diseases, especially cancer. There has been a massive advancement from our clients and companies that we see in their ability to just take a blood sample, a saliva sample, a urine sample, and avoid having to do invasive biopsies and make predictions that even 5 years ago couldn't be done, and it's being forward fueled by machine learning. And in the US in particular, we have this double-headed monster of subject matter eligibility, both as it exists for artificial intelligence, computational aspects, software, and diagnostics. There was a Supreme Court case in 2011 that kind of really really has dispelled a cold spell in the US because the court said that, for example, if you say, you take a blood sample and you measure these 3 genes, and based on X level, Y level, and Z level of these genes, you can predict that this individual has an X% of likelihood of developing this type of cancer. The patent office says that is not patentable subject matter because it's directed to something that is naturally occurring. Whether you measured it or not, that person is walking around with that risk. So for you to get a patent quantifying that risk is just non-patentable subject matter. It is incredibly frustrating for of course, our companies who are really making significant advancements and meaningful impacts on public health to be able to do that when they can't, when they effectively can't protect themselves. There's been a shift in who's doing this work. You're seeing more big pharma who can have a department that does this without needing to get a patent versus smaller biotech companies who would build their whole business around this if they can't protect the invention. So that's an area. There's been discussions around overturning that case by statutorily overturning that case. It's yet to be seen what this administration and what this Senate will do in that regard, but that's probably the only way to fix it at this point.
Before we switch gears and see what should happen next, I would like to open the floor for 1 or 2 questions max, so that it's not just unidirectional. Let us make it more engaging. Any questions, please? 2 questions. Yeah.
So I'll just ask a very basic fundamental question. IP, would it be a deterrent for disruption, or it would really boost disruption? So IP is like some sort of protection on your disruptive thoughts or technologies. Would it actually be a deterrent for disruption in terms it stops at certain point because you invested in your idea, you have protected your idea, and you want to think this is the best idea, right? But how does it really boost disruption? Because let's say for sun mobility, electric vehicle is disruption. But I want to go to the next level of fuel. Would it really hamper going there, or would it also be an opportunity to go there? That's my question.
That's a very good question, actually. So I think IP is going to be an enabler for disruption, not really a deterrent, because when IP happens, let's say someone comes up with a new idea, for example, battery swapping per se. Battery swapping is what Sun Mobility is doing, but it has been there in the patents, so to speak, for more than 80 years or so, where people got this idea about the business model, and then from the business model came the technology solution. When ideas are not necessarily patentable, that we all of us are aware, and at the same time someone got, how do I do it? That's the kind of thing, that's where the inventive step lies, and how do I do it? Of course, the big commercialization happened about 10 years ago by Guru in Taiwan, where they introduced swapping in the industry. I'm being very specific to the industry because you mentioned Sun Mobility. At the same time, that gave multiple countries as well as technologists as well as business-minded people to generate how else I can do it. So once we see a reference point, of course there is always an avenue for doing it some other way, and that's how IP enables the people's thinking and achieving more and more IP. Of course, it generates more business for firms, which is also good. So at the same time, so I think it's not a deterrent at all, it's going to be an enabler. That's what I feel. Yeah, it is necessary.
Yeah, okay. So, is it, I see different perspective. I mean, pharma, long term, so many studies, clinical trials, long lead times, or biotech for that matter. Energy could be on a different scale in terms of time. It takes time. Is this software that's moving very fast? And computer technology even faster. So, and all is driven by data. If you notice, there's a common thread is data. So, do you think there's now the time to think of sectorally differentiated patent protection periods or different treatments? Do you see a need for that? Is it time to think about it?
is a very urgent need to harmonization of patent rules and patentability criteria across jurisdiction, which is not happening. Though there are a lot of efforts being taken in that area, but it's not. We probably need to move into that a little faster with the kind of see, as we discussed earlier, that there is disruptive technologies were happening earlier, but now with the kind of information that's available, is happening at a much faster pace than what was happening earlier. So, as IP professionals, IP stakeholders, we need to also keep pace with that. And one part very important is the harmonization of patent rules and patentability criteria, other rules across various jurisdictions, which will really help inventors and applicants to see what and not have this question mark that okay, I'm going to get this in Europe, but this will not be patentable in the US, and this will not be patentable in India. That's very important. And then, of course, coming up with other alternative, as we said, utility models, which some of the countries are already adopting. We have example of China, where the number of utility models they file is much more than innovation patents, and there, so this model has been working pretty well particularly for technologies which were the span, electronics, telecommunication, but the span is very small. It's there are incremental inventions, and also the span is for 5 to 10 years, and that's what you need, that protection. You don't need 20 years, because anyway in 20 years it's going to become obsolete. So even for design registration, some of the countries are allowing GUI to be registered. So for computer implemented invention, that becomes an important aspect of protection, which some countries have started allowing, but like in India we don't have it, in some other countries we don't. So these alternative means which can grant protection may not be patents, but other alternative IP rights would be really a boon to dealing with this protection of disruptive technologies.
I think it is, as you rightly mentioned, the data has been there for quite 10 years. The exponential rise in the recent years has, I think, probably caught people off guard. That's what I would say. And then in the last 6 months, the two on AI and ML is just mind-blowing. The number of tools that are coming, even for IP, are there. I would say it is the responsibility of the people as well who are in the industry to, upskill the people in the IP office as well. The IP office people may not be even aware of such things. It's actually also the responsibility where we are thinking about, having sessions with them, irrespective of whether patents go in the fast track or a slow track, but it's also responsible of the businesses to get the skill across the industry. That's what I would say.
To add that, I absolutely agree with you, and educating all the stakeholders is absolutely important, be it patent office, be it IP codes, be it the policy makers. And at the same time, answering your question, with regards to specific technology area, we really need to have guidelines in place with respect to these technologies. Say AI, like you said, in US you already have these guidelines. India needs to, the policy makers need to step up and provide these guidelines to avoid ambiguity. We really need to have changes in our law. Section 3, we did a comparison with regards to all the elements of Section 3, and India is one of the most, in the country, having most of these subject matter eligibility issues. So we really need to step up and fix these issues.
Just one quick point about, you asked about patent terms. Should there be different patent terms? Arguably, in the biopharma industry, there's already the ability to get patent term extension or supplementary protection certificate in EP for any delays that happen during regulatory approval. If that can, China has now started that. Some countries have it, but some countries don't. So if that can be internationally harmonized, at least for that sector, there's an understanding that from bench to bedside can easily take 10 to 15 years, and to compensate for that, at least not for the broad claim, but for at least the product.
Question, quick response.
So my question is to you, Mr. Santhu, that what is the energy and hence the environmental cost of this disruption? You know, it's very well known that the amount of carbon that is produced to train one LLM is equal to 60 flights between New York and Paris. You know, so I mean, and we are doing billions of these kind of instructions around the world every single minute now. So what is do we have that kind of energy? Do we, and in a country like India where even basic distribution is a problem, you go outside Mumbai and Delhi, there is no electricity. I mean, people are still facing that kind of breakdowns and all. So the energy and the environment cost of this disruption, we are going at a lightning speed. So that's my question to you.
One thing is clear, that consumption-wise, what we see in the future, there is going to be many folds of requirement. Infrastructure-wise, of course, we will be challenged, and that is also an area where innovation is very much needed. As how we are going to use the existing infrastructure, or what's the way forward. Of course, there may be a way forward, like what we can learn from developed countries, or what we could have as a separate things which could help us meet there. What I'm saying is, it is absolutely necessary for climate and maybe for regulatory reasons that we need to go there. But how to go, that's the innovation space. And that is what, maybe it is different for different countries. The challenges may be different, but we need to work that out. Of course, it's a cost, it's big disruption in terms of what we have been planning. But I think the sensitivity is there, and investment would also happen here to reach there. We may be lagging, but that's a gap we need to fill in and move.
Okay. Thank you. Interesting questions, interesting responses. Is there one key takeaway that you want your audience to take?
We have a collective duty as practitioners, as we heard our clients and our inventors, to really understand these disruptive technologies. And if we don't, make sure we bring in juniors, fresh grads who can understand it, so we describe it well, so we have what we need in the four corners of our specifications to fight with patent offices, to educate them and to get the claims that these technologies deserve.
Yeah, it's very, I would say that when we are dealing with our inventors and companies, we need to foster transparency and disclosure, because sometimes when we don't disclose enough, then it falls, then the inventor step is not clear, the novelty is not clear, and that really causes the problem in sort of getting there. So fostering transparency, disclosure, especially along with a practical example of how it's going to be applied, that will go a long way in patentability of new technologies.
The main thing is, I think, all along, probably from the past 50, 70 years, we have been focusing on people and profit. And of course, they are important. Disruption should not be at the cost of the planet, because that's where we need to live and we need to sustain this. So think of sustainability as the main thing, considering people, profit and planet, and disruption should aid towards that. I think we are getting there, we will get there. Thank you.
So yeah, disruptive technologies as a aid in terms of biotechnology and gene-based therapy, curing disease at a genetic level. So we really need to proactively engage in these technologies. If we still don't have an advantage, we can look into developing application-based therapies, application-based solution to further these technologies. Also actively engaging and keep filing applications, multiple applications, and without losing much patience, because it will take time, especially in this space, but filing multiple applications and the clarity would come in. And at the same time, at the government and at the policy makers level, we need to engage into the discussions with the industry and understand that at this fast moving pace, we really need to look at to our patent laws and do something about that.
From my perspective, I mean, we could look at technologies as OT technology, operational technologies, or IT technologies, or combination IT and OT. And there may be a different ways in how we patent this or how we protect innovations in this area. Particularly for IT, I feel more and more enablement part has to be thought about because there may be inventive related challenges. It may be easier to show in OT, so I'm only saying in a relative manner. And there we need to work, as the previous panel also it was mentioned, we need to work with inventors, gather enough information and enable the patents very well for various use cases and thereby reduce also the challenges related to inventiveness or abstractness. Thank you.
In the paucity of time, we have to end this session, but we had few other points to talk about. We wanted to talk about the dragon in the room and a few other interesting topics, but we'll save it for some other day. Thank you so much. I have enjoyed being a moderator for this panel, and thanks to each of you. Thank you very much.
Thank you very much for that wonderful panel discussion, very much needed at this time in on disruptive technologies and their patentability. So now I'd request Dr. S.K. Murthy to please hand over and felicitate our speakers. First, Dr. Madhuri Roy from Cooley LLP. Next we have Dr. Neeti Diwan from RK Diwan and Company. Next, Mr. Karthikeyan Srinivasan from Sun Mobility. Ms. Manika Arora, Associate Partner at Lal and Sethi. And Dr. S. Senthil Kumar from Hitachi Energy. We also have a token of appreciation to Dr. S.K. Murthy. I'd like to request all the panel members to please pose for a group photo. I think we had a great start to the day with discussing the IP progress in Europe, followed by the impact on IP law with computer-related inventions, and then now finally patentability in disruptive technologies. So now we shall take a short break for lunch. Please head back here at 1:20 p.m. to join us for the next set of sessions. Thank you very much.